and the basic structure theory. Lord, that was interpreted, Lord, in Minerva Wills. It was read through in Vaman Rao, as I'll show your Lordship. And, my Lord, we are now presented with the effect of the Coelho judgment. Because, my Lord, the language of 31C, and your Lordship will just see the wide language, Lord, it brooks no interference with 14 and 19 rights. So, my Lord, and there's a lot to be said, my Lord, with regard to how you will.
Let's read the statute.
Would your Lordship mind, my Lord? My Lord, if your Lordship will come to 31C.
Statute, the provision. Yes.
My Lord, I have prepared a short note on Coelho also. I'll just come to that in a bit. 31C, saving of laws giving effect to certain directive principles. Notwithstanding anything contained in Article 13, no law giving effect to the policy of state towards securing. Now, my Lord, this is the portion which was struck down in Minerva Mills, all or any of the principles laid down in 39(4). Therefore, your Lordship will read it in the old language, which says in relation to 39B and
37 in our books.
Yes, your Lordship is perfectly correct.
The principles specified in clause B of clause C of Article 39.
Perfect, my Lord. So that is, my Lord, my revival argument.
Shall be deemed to be void.
Shall be deemed to be void on the ground that. Now, my Lord, please note the sweep of this, my Lord, that it is inconsistent with, or takes away, or abridges any of the rights conferred by Article 14 and 19. Now, the latter italicized portion is the portion which was struck down in Keshav Nanda Bharti. So, my Lord, today, my Lord, with the Coelho judgment, Lord, it is very difficult to understand what force remains in Article 31C. 31C undoubtedly valid as rule.
Then, Mr. Andhyarishna, if you argue that, you are virtually then asking for a reconsideration of the correctness of Keshav.
No, I'm conscious. No, I'm fully conscious of that. Lord, that's an outrageous argument, and my Lord, so Lord, yes, Lord, the logical extension of the Coelho argument may take us to Keshav Nanda Bharti. That is true, but your Lordships are presented with a 31C problem. I have some solutions to that, Lord. If the occasion arises, Lord, I will argue that.
Coelho was essentially with 31.
Because, Lord, what meaning is left in 31C if we say that every aspect of 14 can be used as a challenge?
But we are a bench of 9. We are bound by the principles which have been laid down in Keshav and Bharati, which upholds 31C as it was originally enacted.
Correct, sir.
And as originally enacted, 31C gave, as you rightly said, it's a safe harbor provision in respect of a challenge to the laws giving effect to the directive principle contained in 39B and C on the ground that it violates Article 14 and 19 of the Constitution. Now, that has been upheld by a larger bench of 13, or by a bench of 13.
By a bench of 13 judges.
For us, that's now a dictum. I mean, that's a given, that 31C is valid.
I accept that.
Right? And therefore, there's no reason for us to go into the impact of Coelho on the correctness of the decision on Keshav and Bharati.
So, my Lord, that is a very far-reaching proposition. Your Lordships are right. And, my Lord, against that suggestion, Lord, if at all I made it, my Lord, is of course the Minerva Mills dicta, Lord, where actually they said that whatever be the case.
These walls are witness to what happened after Keshwanand, when a review was assembled in this very court, and then abruptly it was discharged. We'll not forget that history of our court. We'll now allow Keshwan to rest where it is.
No, but long may it rest in peace, my Lord, undoubtedly. My Lord, so, Lord,
not just rest in peace, but as a vibrant part of our discourse, isn't it? As it is today. Because once we open up the canvas, there'll be.
Then we'll say that 6 judges are right.
Continue to guide us.
No, my Lord, I don't say that. But just bear with me for a minute, my Lord.
Guide us.
No, my Lord, so the Minerva.
With 31C in its original form, as upheld in Keshwan, we'll of course we'll see Coelho for 5 minutes with you, no difficulty.
No.
We'll treat 31C as upheld in its original form by Keshwan Bharati to be the position which binds a bench of 9 judges, and then we accept it,
Lord, accept it, my Lord. But may I just point out to your Lordship, my Lord, that Coelho presents a problem for your Lordship, Lord, in this case, in this sense. Lord, what are we to do with Coelho if we accept the validity of Article 31C? Because I mean, my lord, your lordships sees that it is quite obvious that 31C is now effectively emasculated as far as it comes up against 14 and 19. But 14 and 19 challenge now in view of the Collier judgment is a basic structure challenge. My lord, assume that 31C was brought in for the first time by an amendment today. My lord, it would be beyond the amending power of the Constitution. And being beyond the amending power of the Constitution, it would be void. Now, my lord, I quite appreciate everything that your lordship has said, but it is a very serious issue which arises, my lord, in the context of 31C. Now, my lord, I show your lordship Collier. But Collier was a judgment actually under 31B. What the question framed in paragraph 5 was under 31. Correct. 9 schedule question. Lord, they don't actually strike down 31B. In fact, what Collier veers towards is an exposition on fundamental rights. And there are some questions that arise, but one thing it does is that it entrenches these three, Lord, 14, 19, 21.
Those laws which were inserted in the 9th schedule as of the date of the judgment in Keshwan Bharati are immune.
Yes, your lordship is right.
Those laws which were inserted in the 9th schedule after the 24th of April 1973 would be still amenable to a challenge under...
but which is exactly, if your lordship recalls, what the majority also said in Minerva Mills. Which is what...
In Vaman Rao, it was sustained, this view. But
Minerva Mills. I'll show your lordship. Vaman Rao and Minerva Mills, both. Now, Lord, the point that I leave your lordship with, and the point for consideration...
You know, really speaking, why should a bench of 9 go into these issues at all? You know, the first thing you ask yourself is, why 9? What is the occasion for 9 and not 7? And the occasion for why 9, why not 7, why not 5, why not 3? Actually, you know, the reason for the constitution of a 9-judge bench is obviously because there's something operating in a 7-judge bench, which is a matter of concern. Now, actually, in this case, Ranganath Reddy, the bench of 7, has not said that 39B will include resources of a private nature, right?
Majority.
In fact, it's quite to the contrary. Justice Upadhyay specifically in his majority opinion keeps that issue open, saying that we are not
agreeable with...
We shouldn't be construed to have agreed with Justice Krishna's viewpoint. The problem, yes, there's a specific paragraph on that.
Yes, ma'am.
Now, the problem arose because Sanjeev Coke lifted Justice Krishnaiah's perception on the interpretation of Article 39B and made it a bench of 5. Now, it could have been resolved by 7 also. It could have been resolved by 7 by saying that, look, what was done in Sanjeev Coke was plainly incorrect because it overlooks that the view of Justice Krishna was a view of a minority on that subject, or at least a plurality and not a majority in Ranganath Reddy. But the 7 judges thought that we should refer it to 9 only because in the meantime Mafatlal has come. And Mafatlal has that observation in para 86. Now, if we come to the conclusion that, look, that observation in Mafatlal is obiter, because Mafatlal was really dealing with unjust enrichment. There's an observation that would end the issue on Mafatlal, 1. 2, if we then construe the judgment in Sanjeev Coke to the extent of interpreting Ranganath Reddy, we'll say that the bench in Ranganath Reddy, the 7-judge bench, has not laid down this principle at all as a principle of constitutional law. Of course, we are a bench of 9. We can still look at the interpretation of 39B, whether it will apply cover private property as well. And you may argue that 39B should not cover material resources of the community cannot mean material resources of a private person. That is something which you can certainly argue before us.
No, my lord, I leave it up to your lordship, my lord. As I said, it is your lordship's reference.
31C argument here, you know, we're 45 minutes short of lunch. We'll all have a conversation between ourselves.
But in the meantime, yes, but I fully appreciate what your lordship says, and it is your lordship's order of reference, but it is for your lordships to decide. And of course, the 39B point can get us home as much as the 31C point as well. So, my lord, that stands.
31B is essentially
My lady.
a validation provision. They wanted to validate certain things by virtue of that.
The 9th schedule. 9th schedule.
Prejudice itself.
Yes.
So it has a restrictive scope also. 31B has a restrictive scope.
Yes, my lord, what your lordship say, my lord, what resonates with me. In fact, that is our argument. Mr. Devarajan will make it for us. My lord, that actually, my lord, it is difficult to say that private property falls within 39B. My lord, that the so-called concurring judgment, it's called a concurring judgment, my lord, delivered by Justice Iyer, Justice Krishna Iyer, where he says that I agree with everything, but it's such an important issue, so I want to say something more on it. And my lord, he then slightly extends the principle in an axiomatic way to say that actually private property is obviously a part of 39B. And as your lordships have rightly pointed out, subsequent judgments have picked up that observation which was made by Justice Krishna Raya. And my lord, if at all, my lord, the consequence, the impact on this case, if that it is not a part of private property, my lord, then a large part of our challenge, my lord, has a good chance of succeeding. So, my lord, that is how the impact lies on our case. And your lordship's absolutely right about 39B. My lord, I don't think I can say more on 31C. Lord, your lordship's interpretation of the reference order, of course, my lord, is, my lord, perfectly correct. Lord, I had only thought that the impact of Colio was something that required consideration by your lordships. Because the problem with Colio.
Look at Coelho. Please show us Coelho.
Can I show it to your lordship?
Let's go
Your
to
lordship.
Coelho because we.
But in the time left, my lord, will your lordship
Yes,
just have a
certainly,
look?
let's
My lord, I've prepared a very short note, but I wonder, would your lordship like to see the judgment itself? That might be better.
You have your note here.
I have a note where I've extracted actually, my lord, because all these judgments are so long. So, my lord, I took the liberty of making some extracts. It's uploaded.
That'd be nice.
It's uploaded.
Is it uploaded?
Yes.
Is it?
But it's it's actually comprehensive in the
Let's
sense
put
that
a
it,
note in.
yes. So, my lord, if your lordship will, if, my lord, the court will kindly furnish your lordship, my lord, with an email sent by my learned friend, Mr. Parekh, my lord, at 9:56 this morning. Should have please.
to 39B in that dichotomy, that 39B can never include private property. That will be very artificial, because when it says material resources of the community, is agnostic to title. It doesn't mean that, well, where the title, it doesn't make that, distinction between a case where title vests in a private person as opposed to title in the community.
Or I see that point, but Lordship is
In a
right.
given case, take mines, for instance. They may be private mines, but in a broader sense, these are material resources of the community. The title may vest in a private individual, but therefore, for the purpose of 39B, our reading should not be constricted, but must have that broad understanding of 39B.
So, Lord, you're-
Political sense.
Or take a case like these buildings in Mumbai. Technically, you're right that these are privately owned buildings. But what was the reason for the law? We are not commenting on the legality or the validity of the law. That will be tested independently. The reason why the state legislature came out with this was that, these were all buildings, old buildings of 1940. With the kind of monsoon in Mumbai, these buildings get, dilapidated because of the saline weather. You know it better than me. Because of the
Only
saline
slightly.
weather. That, the fact that the rents were so meager that the landlords had no motive to at all to repair them. So where will the landlord, poor fellow, find any money to repair the buildings? And the tenants were sitting tight that no one tenant would have the wherewithal to repair the whole building. So therefore, the legislature had to. So these are, in a sense, what do you mean by material resources of the community? Material resources of the community would mean resources in which the community has a vital interest. If a building falls, the community is directly affected, because who dies when a building falls? The occupants die. Therefore, we must
Community and
distance it from a title.
Lord, there is no doubt that
Common good.
there is no doubt that it is not a question which is free from debate. Lord, and there is no doubt that these considerations have to be taken into account.
In bit of 39B, we have to answer as a bench.
But that is a specific point raised.
See, we were just discussing between ourselves. One way would be to say, accepting what the reference order says, that look, Ranganath Reddy didn't decide this issue. Sanjeev Koch was wrong in picking up on the judgment of the minority and then treating it as a bench of
As a majority.
principle,
Yes.
and applying it in Sanjeev Koch. But even if assuming we do that, then what? The point still survives, and I think with this issue we should resolve.
No, your
for
Lordship
ourselves.
has to grapple with the issue
Subject to the
substantively.
other side, that 39B, the ambit of 39B is something which we should decide. That is the scope of the reference, in fact.
39C.
C is
The way we take it, that Mr. Devarajan would be arguing that 39B cannot include private property at all. And you would be saying that it can,
It can.
right? But
Yes.
obviously you will be addressing us as a matter of first principle also. We
Yes,
take
of
it.
course.
You're not going to only rest it on Sanjeev Koch, because
No,
you will.
no. On first principles also. Your Lordship may decide the ambit
Because
of.
we have to decide it.
Then
We are
Lordship
a
may-
bench of
Yes,
9. We are not bound by any of
So
these.
that's the reference your Lordship has to decide. And it will be better, but otherwise, again, this.
And there'll be some finality to this, you
Yes.
see, because what's the point in again having a ping pong bottle
That's
that
right.
will go before 7, then 7 will again have to interpret what Mafatlal meant. At least we in 9, we can at the least say that Mafatlal was orbiter
Yes.
and then decide it. We may still come to the same conclusion. But 7 can't, then 7 will be bound by even the orbiter of Mafatlal.
So it may not be enough to say that Lal is orbiter and leave it at that and send it back. That may not be appropriate.
We
but
will have to decide it.
Lordship may decide.
It's desirable that
Yes, yes.
So, that means we are.
Karina,
Yes.
I thought we laid the cards very bare that, ultimately, let's not again revisit the correctness of the constitutional validity of 31C on the basis that Coelho would have some bearing on the correctness of what, because Coelho was doing it in 31 in the context of 31B. Coelho was bound by Keshava and Bharati.
No, my lord, I've consulted my colleagues also. And my lord, we have no objection either way. We are happy either way. If your lordship was to hear us, we are happy. If your lordship sent me home early, I'm happy with that.
No, nothing of
My lord, on the other hand,
This, as an act of judicial statesmanship, we should be very careful about,
no,
opening up a canvas which may then have untold ramifications.
no,
on
my lord,
the
I
policy.
fully see that. My lord, I fully see the significance of the point. And we have some arguments on Coelho, which we can run.
But you've put in so much of hard work. Why don't
No,
you
no,
show
no,
us
my lord.
your
I'm very
note on
happy to
Coelho? In any case, there's something interesting.
I will show it to your
sort of
lordship in a
like
few
cross
minutes.
your note. We'll
My lord,
see your note.
yes. And my lord, just to step back from that. So, my lord, our position, my lord,
Opposing you have three academically oriented members of the bar, the attorney himself, Mr. Dwivedi, in any case, Mr.
The lighter side, I was telling them, all of us are material resource of the community.
Most valuable.
The only issue is not to be distributed on the private side.
I think the compliment should be paid back to the bench, my lord.
With their
But
resources is the question.
Home for dinner.
my lord, speaking for ourselves, my lord, we are perfectly content with that. My lord, we will argue the Coelho point, my lord, before a smaller bench once your lordship takes a view on 39. There's no problem with that. My lord, we have various ways to deal with Coelho, so we can do that. There's no problem. If your lordship would like to see Coelho, my lord, I'm happy to show your lordship what we have. On
Since we
Coelho.
have put it,
It is actually a very, very
let's
interesting
just
issue.
look at it.
It is a very interesting issue for more reasons than one.
B and C.
I won't take more than 20 minutes.
Now, yeah, of course, we are, 31B, of course, creates an immunity for acts in the 9th schedule.
Yes.
But now, how do we apply the logic of Coelho to 31C?
That is the point. Now, my lord, so my lord, let me address your lordship first on that.
Yes.
So, my lord, as I pointed out to your lordship, that Coelho and the question that is also framed there is actually a question which revolves around 31B. Now, my lord, some scholarly critique and criticism of Coelho, Lord, has been precisely this, that it has not really answered the question with regard to 31B, at least to the fullest extent. But what Coelho did was to make a very clear statement on what is included in the basic structure as far as these three rights are concerned, 14, 19, and 21. Lord, I think it would be open once again to some comment about whether it actually captured everything that it said in the judgment in the conclusion. Because in the judgment, it does suggest that, in fact, there are other fundamental rights which could also be entrenched in the basic structure, but it doesn't actually pick them up in the conclusion. Or the other aspect of Coelho, Lord, which, Lord, with the greatest of respect, Lord, I say to the learned judges, Lord, they've laid out a very complicated test for testing 14 against the relevant law. Well, they've laid out two tests. Well, one is the rights test, and the second is the essence of rights test, which they draw back to Nagaraj's case, Justice Kapadia's judgment. Lord, when those two tests will apply is also alluded to in Coelho, and Lord, it is a difficult to understand part of Coelho, Lord, where the suggestion is that the rights test, which they also call the right stroke impact test, will apply where an entire chapter of the Constitution is abrogated, whereas the essence of rights test will apply to an individual article which stands affected or abrogated. What subsequent judgments of your lordship's court, Lord, have been, with the greatest of respect, a little cloudy about what exactly is the scope of those two tests also. But in my respectful submission, at least one judgment has mixed up the two tests as well, as I'll show your lordship. So, my lord, Kolio itself gives rise to several questions. I fully appreciate the fact that this may not be the right forum to tackle Kolio in its entirety, but perhaps my attempt today can be to show your lordship that an appropriate opportunity, Lord, there are some creases which need to be ironed out in the Kolio judgment.
If you're taking 20
So, my
minutes,
lord,
let's look at your.
I'll try to quickly deal with it, my lord. So, my lord, if your lordship will have a look at my note. Oh, yeah, it is. Yeah, it's it. Do your lordships have my note, my lord? My lord, so if your lordship sees the index of my note, my lord, it is Roman 2. And my lord, I've tried to make it comprehensive with regard to what I want to say with regard to Kolio. I just want to show your lordship after that, my lord, one or two paragraphs in Kolio, my lord, which are of particular significance. My lord. My lord, in paragraph 1, my lord, I've just set out, my lord, what your lordships have already read. Now, my lord, in paragraph 2, my lord, I've dealt with the ref. My lord, paragraph 2, my lord. So, my lord, first is the reference in Kolio. Why was it referred? The judgment in IR Kolio.
Para 2, right?
Yes, para 2, if you lordships don't know. But it's at page 27, pagination, top right-hand side. It looks something like this.
Yes. Just go to para 2.
To para 2.
Just go to para 2.
So, my lord, we are on para 1. I follow, my lord, we can follow it here. Please scroll down to paragraph. Yeah. My lord, the judgment in IR Kolio. Notice that there were apparent inconsistencies in the judgment in Vaman Rao and Union of India, in particular between the judgments of Chief Justice Chandrachud and Justice Bhagwati. See paragraph 3 of IR Kolio Supra. Accordingly, the 5 judges in IR Kolio stated that the judgment in Vaman Rao needs to be considered by a larger bench so that the apparent inconsistencies therein are reconciled and it is made clear whether an act or regulation which or a part of which is or has been found by this court to be violative of one or more of the fundamental rights conferred by Article 14, 19, and 31 can be included in the 9th schedule, or whether it is only a constitutional amendment amending the 9th schedule that damages or destroys the basic structure of the Constitution that can be struck down. So, your lordship notes the question as formulated. It's slightly changed when the 9 judges actually dealt with it. Further, the 5 judges in Kolio also noted that the decision in Bhimji Singh Ji case will also have to be considered by the larger bench for the purpose of arriving at a conclusion aforementioned. Now, just by way of a temporal context, your lordship is aware, but Vaman Rao, Minerva Mills, Lord 1980. Lord Minerva Mills, July 1980, Vaman Rao, November 1980. But
Definitive order pronounced on the same day, 9th May 1980.
Exactly. My lord, interim order pronounced on the same day, reasons given separately, but one before the other. But unusual for of great academic interest for various reasons. My lord, magisterial dissent by Justice Bhagwati in Minerva Mills, picked up as Sanjeev Kok, as your lordship notes. Lord Vaman Rao, my lord, deals with the unamended Article 31C, upholds it not because of Keshav Nanda Bharati, but on independent reasoning, which is in parity with upholding Article 31A on agrarian reforms. Lord, on the other hand, my Lord, in Minerva Mills, Lord, an interesting point, my Lord, that the Sikh Industries Act, which was challenged there, was actually an act which took effect prior to the amendment to 31C. But yet 31C was struck down, Lord, on the annual of 14, 19, and 21. And Lord, I think that is what is referred to broadly also in this. Now, my Lord, the judgment in IR Polio. And I've put here, my Lord, actually, my Lord, what the question was and the facts to allow us to actually understand what was decided. The matter was duly referred to a bench of 9 judges. The judgment is reported in so and so. The challenge before this High Court was that the Gudalur Jannam Estate Abolition and Conversion into Rayatwari Acts 1969, insofar as it vested forest lands in the Jannam Estates in the state of Tamil Nadu, was struck down by this court in the Balmadis Plantation Limited because this was not found to be a measure of agrarian reform protected by 31A of the Constitution. Section 2C of the West Bengal Land Holding Revenue Act 79 was struck down by the Calcutta High Court as being arbitrary and therefore unconstitutional, and the special leave petition filed against the judgment of the state of West Bengal was dismissed. By the Constitution 34th Amendment Act, the Janmam Act in its entirety was inserted in the 9th schedule. By the Constitution 66th Amendment Act, the West Bengal Land Holding Revenue Act in its entirety was inserted in the 9th schedule. These insertions were the subject matter of challenge before the 5-judge bench. So, the very troublesome aspect of the 9th schedule was that after a court had set aside a statute, despite the constitutional basis of it being set aside, not being altered by Parliament, they could simply validate it by putting it into the 9th schedule. Well, that has been long the criticism of the 9th schedule. But the contention urged before the Constitution bench was that the statutes inclusive of the portion thereof which had been struck down could not have been validly inserted into the 9th schedule. The judgment, now, the question, your Lordship will immediately notice a slightly different question from the question referred. Lord, the fundamental question, Lord, as my lady pointed out, Lord, on and after 24th April 73, whether the basic structure document was propounded, it is permissible for Parliament under Article 31B to immunize legislation from fundamental rights by inserting them into the 9th schedule. And if so, what is the effect on the power of judicial review of the court? So the question frame, not against me, on the 31C point, is that it was squarely a 31B question, which was framed. But my Lord, please see now how it was answered. Now, my Lord, I'll take your Lordship straight to the conclusions, my Lord, longish judgment, 150 odd paragraphs. In conclusion, we hold that a law that abrogates or abridges rights guaranteed by Part 3 of the Constitution may violate the basic structure doctrine or it may not. So, my Lord, not every part of Part 3 is a part of the basic structure. But a classic example, what I've often puzzled about is 18, my Lord, titles. Lord, it seems to be an odd inclusion in Chapter 3. But Lord, it seems to be strange to say that it is an inalienable human right, etc. So, Lord, they've noticed that. They've said not every part of Chapter 3 is actually entrenched. If the former is the consequence of law, whether by amendment of any article of Part 3 or by an insertion in the 9th schedule, such law will have to be invalidated in the exercise of judicial review power of the court. The validity or invalidity would be tested on the principles laid down in this judgment. The majority judgment in Keshavananda Bharati, read with Indira Gandhi's case, requires the validity of each new constitutional amendment to be judged on its own merits. The actual effect and impact of the law on the rights guaranteed under Part 3 has to be taken into account for determining whether or not it destroys the basic structure. The impact test would determine the validity of the challenge. Now, the impact test is viewed what's called interchangeably the rights test or the impact test. But Roman 3, all amendments made to the Constitution after 24th April 73, the date of Keshavananda Bharati, by which the 9th schedule is amended by inclusion of various laws therein, shall have to be tested on the touchstone of basic and essential features of the Constitution, as reflected in Article 21, read with 14, 19, and the principles underlying them. To put it differently, even though an act is put in the 9th schedule by a constitutional amendment, its provisions would be open to attack on the ground that they destroy or damage the basic structure of if the fundamental rights or the rights taken away or abrogated pertain to the basic structure. Justification for conferring protection, not blanket protection, on the laws included in the 9th schedule by constitutional amendment shall be a matter of constitutional adjudication by examining the nature and extent of infraction of a fundamental right by a statute sought to be constitutionally protected, and on the touchstone of basic structure doctrine as referred to in Article 21, read with 14 and 19, by application of the rights test. Now, here comes the second test, and the essence of right test, taking a synoptic view of articles in Part 3 as held in Indira Gandhi's case. Applying the above test to the 9th schedule laws, if the infraction affects the basic structure, then such laws will not get protection of the 9th schedule. This is our answer to the question referred to us, Vide Order 14-999 in IR Kolio and State of Tamil Nadu. So, my lord, so far, my lord, it would be difficult to say that this is a 31C judgment. This is very much a 31B judgment. I fully appreciate that. Lord 5, if the validity of any 9th schedule law it has already been upheld by this court, I'm so sorry, my lord, small error, it would not be open to challenge such law again on principles declared by this judgment. But that was the pernicious effect of 31B. But however, if a law held to be violative of any rights in Part 3 is subsequently incorporated in the 9th schedule after 24th April 73, such a violation infraction shall be open to challenge on the ground that it destroys or damages the basic structure. As indicated in Article 21, read with Article 14 and 19, and the principles underlying thereunder, action taken and transaction finalized as a result of the impugned acts shall not be open to challenge. Now, my lord, some of the salient features are set out here. My lord, before I go to the salient features, my lord, your lordship knows enough of the judgment. My lord, just to take a view, I'll take your lordship to my submissions on this and come back. My lord, the salient features, my lord, I must confess to plagiarism, my lord. I've taken them from my learned friend, Mr. Devarajan's note, which he had kindly shared with me, my lord. My lord, he had done such a masterly job of it, my lord, I saw no reason to alter it in any way. My lord, may I take your lordship, my lord, straight now, my lord, to the conclusions that I have drawn in paragraph 9. But I'll come back if necessary to the salient features. But more broadly speaking, what the judgment does is that it broadens the defense that is given by fundamental rights. Lord, it is said it is no longer an isolated pools. It should be viewed as the principal controlling influence over the amending power. So, Lord, that is the broad thrust of what this does. Lord, there are certain observations with regard to 31C I'll come to. Now, Lord, the conclusions I have drawn, Lord, are these. Well, the conclusions that can be drawn from the judgment in IR Kolio as stated below. When a law abrogates or abridges rights granted by Part 3 of the Constitution, it may or may not violate the basic structure doctrine. The test to be applied is either the rights test or the essence of rights test. The rights test is as under. First, the court must test whether there is a violation of Part 3. And second, if such a violation is found, its impact must be examined in terms of its effect and substance to see whether it destroys the basic structure of the Constitution. In the event it does, then I quote, invalidation has to follow. The essence of right test is explained in M. Nagaraj's case. Within Part 3, 14, 15, 19, 20, and 21, your lordship noticed that this was not recognized in the conclusion, but it is in the body of the judgment, are recognized as a part of the basic structure. The validity of 31A and 31C were not questioned and accordingly expressly held to be valid. Now, Lord, this is the interesting observation, despite the denial of Article 14, and on the basis that these articles have indicia, which is not there in Article 31B. Now, my lord, some observations on the impact on the present case. And my lord, your lordship will take all of this in the spirit that, my lord, I accept what your lordship say, and my lord, it may or may not be decided by your lordships. My lord, applying the essence of rights test. My lord, essence of rights test, my lord, slightly different from the rights test. My lord, summarized to mean that we must go behind the principles with each of the fundamental rights. My lord, I had thought, my lord, that a reference to essence would be a narrowing down of the right, but actually it is a broadening of the right. What it says is that we must go by the principle of the right. So we must read the Constitution as a whole for that. So Article 14 should not be read, for example, in a formalistic manner, but we must read it in a broad manner in accordance with the spirit of Article 14. Applying the essence of right test since 21, read with 14 and 19, the principles underlying them have been held to be a part of the basic structure. Article 31C, insofar as it is inconsistent with or abridges rights under Article 14, destroys the basic structure. Even applying the rights test, the same result follows. Accordingly, the consequence Now, my lord, is that invalidation of 31C has to follow. Now, my lord, this is controversial, I see that. But my lord, let me set out my thought process for your lordship. There was no challenge to 31C in IR Colio. The statement with regard to 31A and 31C and the fact that they differ from 31B should be understood in that context. In the present case, the question of 31C squarely arises, and other things being equal, but what I mean is if you exclude Keshav Nanda, etc., and subject to what is stated below, it is open to this honorable court of 9 judges to examine the validity of 31C. This is especially so as Colio has observed that 31C results in a denial of Article 14. The determination of the validity of 31C in Keshav Nanda Bharti is, however, binding. 31C was upheld by a majority of 7 judges, 6 judges, and 6 judges as, sorry, 6 judges, Chief Justice Ray, Palekar, Dwivedi, Matthew, Beg, and Justice Chandrachud, as he was then, held that it should be upheld because of the amending power of Parliament was absolute and unlimited. Justice Khanna, even on the basis of the limited power to amend, upheld the validity of Article 31C. In this regard, see Justice Bhagwati in Minerva Wills. But he has done a masterful analysis of this aspect. The impact of the judgment of Colio is, however, to render 31C without any force. The validity of 31C, while binding, is a matter of precedent, is depleted of purpose. Now, my lord, there's some follow-up also, my lord, which is there. Follow-up all concerns the test, but if your lordships are not going into it, or it may not be very relevant. So, my lord, this is the issue with regard to Coelho. My lord, with the greatest of respect, my lord. Deeply appreciated.
Thank you, Mr. Thank you, Mr.
Deeply appreciated.
Yes, Mr. Devaraj. You are going to be arguing the 39B point basically.
Yeah, they have noticed that. So, obliged.
say that.
Maybe there. What did I say?
My Lordship's kind permission, my Lords, before I attempt to interpret 39B, I would request your Lordship to have a look at section, Article 39. The state shall in particular direct its policy. Our case is that if it's a policy of the state, it can't be restricted to a few wards in a municipal corporation. That's our first case. Our first point is on the question of policy.
That may be a ground to challenge the act.
The act is under challenge, my lords.
That is before the bench which will hear the challenge to
So
the act.
I go before your lordships, but when it comes to an interpretation, my lords, one point that your lordships have repeatedly been saying that if we feel that it's an academic question, we will not decide it. The point I'm trying to make here is twofold. One, before we go to question whether private properties would be material resources of the community or not, the question that we need to consider is what is material resources, one, and two, in respect to the matters before your lordship, is there a material resource? I fully bow to what my lord the Chief Justice said. We are not entitled to the property. We are on whether it's a resource of the community. My lords, again, the question here is not just resource of the community. Is it a material resource of the community? I'm emphasizing the words here, my lord. I'm on policy and I'm on material resource. Before I come to the question whether private can be included or not, this question might kindly be considered.
Must also bear in mind,
Please.
material resources of the community is in the context of distribution.
I bow before your lady. I bow before your ladyship's suggestions, my lady, because our case further, when we go through, I will take the liberty of taking your lordship through the act. Only that's chapter 8A, because that might clarify quite a few points. Is there a distribution of control? Is there a distribution of material resources? Now, material resources, once I can zero down and say that material resource should be that resource which produces goods or services for the community. If it does not produce goods or services, it would not fall within the category of material resources. That is my humble submission for your lordship's kind consideration. Here, my ladies, what is the situation? The situation is a cess was levied on these landlords and tenants for carrying out structural repairs. The state says it is our duty to carry out structural repairs. When I say state, my lord, I refer to the board. If they don't carry out structural repairs, they don't give me the wherewithal to carry out repairs. My rent is frozen at 1940 levels. The cost of all building materials, construction materials are shot up, and I'm not put in a position to carry out repairs. Would such buildings form a material resource, much less that of the community? This is a question which I would try to satisfy your lordships, that this is not a material resource, much less of the community. That's the first.
Clause B. Clause B has 4 aspects. The primary aspect is material resources of the community.
Oh.
What is it dealing with? It is dealing with the distribution of the material resources of the community. What facet of distribution is it dealing with? It is dealing with ownership
And control.
and control. Because are so distributed qualifies ownership and control.
Correct.
Ownership and control of what? Of the material resources.
And for
But
what purpose?
distribution of what? Distribution of the ownership and control of the material
Material resource. Now we are.
Now, what is the object? To subserve the common good. And the fact that the legislature, that the constitution uses the expression ownership and control is very significant. Ownership refers to the title or the vesting of the title. Control is much broader in its understanding because it's not confined to title.
Here, my lords, I'm raising two issues for your lordship's kind consideration. The first, as I already indicated, my lords, when the constitution says that the state policy of the direct its policy, now would it be only for the city of Bombay? Would it be only for the district of Nasik, or should it be that policy should be over the state? This is the primary question.
That wouldn't worry us because then the state can always make an under-inclusive classification.
Yes.
Then you say that, look, the condition of the buildings in Mumbai is so unique that you don't have to legislate, you don't have to regulate the entirety of the state. That the state can easily,
So
that
here,
is not an issue at all.
my lords,
On
if
first-
it were a regulation, my lords, I would have bowed to your lordship's suggestions immediately. But here it's not a regulation, my lords. Here it's not a regulation.
Oh, we are not so much today interpreting the provisions of the statute as we are
No.
interpreting the expressions of clause B of Article 39.
I bow to what my lord the Chief Justice has said, but I request my lord the Chief Justice to kindly consider whether we could interpret this, dehouse the facts before us. Because this question has come to your lordships on the basis of certain facts which were there.
But when we are interpreting Article 39B, we don't interpret it in the context of that statute today before the bench of 9 judges.
I would request your
We
lordships
have
to
to
kindly
really
consider
whether
it.
there is a dichotomy between privately held property and publicly. For instance, will 39B cover only those lands which are what you call in Maharashtra Gairan lands or the grazing lands? Or would it also cover in certain cases private
Only
property?
one interjection with so that your lordship's discussion can also be suitably. Resources, psychologically because of MHADA and Rent Act, we are considering land and building. The resources would mean several mines, minerals, airwaves, etc. Several things.
Natural resources as well as man-made resources.
Yes, exactly. Not just land or buildings. That also may be one of the focus of examination.
My lord, I have no difficulty in the term resources. I have difficulty in submitting to your lordships that my building would be a material resource. Because your lordships have time and again held. Sorry.
So Devarajan is that, look, the MHADA Act contains a declaration that it is intended to give effect to the directive principle contained in 39B. Your contention, I mean, we are just trying to understand your argument. Your argument is that, look, you could not have made that declaration because 39B cannot by any standard extend to private property. I think that's your,
No, my lords, my submission is slightly wider than that. What your lordship says is one part of what I'm submitting. My second part of it is, before you could make such a declaration, because your lordships and Keshananda said this is justiciable.
Make the declaration.
Before you make a declaration, you must come to the conclusion that it's a material resource.
Obviously.
I'm on that. I am trying to make a submission.
According to this can't be material resource.
According to me, it can't be a material resources. Old dilapidated buildings cannot be material resource of the community. This is my submission.
Questioning the declaration itself.
In a way, my lady, in a way, I'm trying to interpret 39B to say that before 39B can apply and the subsequent things can follow. Yes, what I interpreted, as my ladyship said, I need to go through the act to interpret the rest of 39B.
But why can't?
But I'm not going
Why
there.
can't it be interpreted like this, that any building, old, we are not dealing with a building. Buildings which are in the occupation, old dilapidated buildings in, say, like the island city, which are in the occupation of a large mass of occupiers and tenants, they constitute a part of the material resources of the community because ultimately it's a source of habitation and abode for such a large group of citizens.
My Lord the
And
Chief
decorate.
Justice, I go to what your Lordship said, but my Lords have time and again said, made a distinction between a resource per se and material resources. This is where I would try to convince your Lordships that yes, this is a resource, but is it a material resource?
Just one,
Oh, I'm sorry.
add to what the Chief Justice has asked you. The material resources of the community, when you look at that expression, are we not also looking at the community of inhabitants in a dilapidated building?
Please, my Lord.
Because if you look at their need,
Yeah, come.
a building is crumbling down, a building is no more safe. So community who are occupying that building, it is a material resource and a vital material resource for them.
Again, my Lord, I could not make my point clear.
No, no, I'm
That
saying
it is a
compare-
resource, that it is a resource the petitioners don't dispute. The question is it a material resource? Because your Lordships have said, for a resource to be a material resource, it should provide goods and services for the community. What is my building
Yes,
doing
sir.
so?
It provides a service. What is more fundamental than the right to housing?
No.
It provides a place of abode
No,
for such a large segment of the community. Take a building which has, say, 70 occupiers or 40 occupiers. It's a community, as Brother Rishikesh Roy says, that it's a community of occupiers.
Why the community will have to buy for this community?
Absolutely.
Yeah, just continue.
Get to
Yeah,
it.
please, my Lords.